Don't worry, you still look great. And I'm a month older too, so it's been a long time. And I'm sure your memories are fading a little bit. So let's spend a little time going back and refreshing our memory on where we were. Remember, we're in basically two worlds in admin law. We're in the world of procedural fairness. That's where we are right now. And then we're in substantive review. Those are the two big areas of admin law. And in the first two classes, we got pretty far in procedural fairness. And I rolled out this framework for you guys. And let me use that to kind of remind you of where we are and what we've learned and kind of what's coming up. And you're probably going to have questions as well as we kind of refresh our memories here. And that's fine. That's all good. So what I like about this framework is it helps us know how to tackle a problem, right? Because that's what we're always trying to do. Recognize what's a procedural fairness problem or question, and then where do you start, right? That's always the hardest part, right? Where do you start? Once you're into it, it can get easier, but where do you start? So this is the way I like to think about it, and it won't surprise you when you don't remember that the thing I put at the top in A there is read the statute and the regulations, right? Because we know that many of our procedural fairness PF problems can be resolved by looking at the statute, because that's always the first place you look, right? When you see a DM, you always know that they're acting under a statute, right? Because a DM without a statute is nothing. They all have a statute. They have some kind of power that derives from the statute. And we know that statute can say maybe a little bit about procedure, or maybe a lot about procedure. It depends. There's no rule. Legislatures they do what they do, right? And you're stuck with it. And the DM's stuck with it. So that's what you want to do, is you want to look and see, who is this DM and what does the statute tell them? What does the legislature tell them about how they're supposed to do their job? Make their decisions. Hold their hearings. They don't always hold hearings, but it tells them procedurally how to do their job. A little bit or a lot. So, and the easy example is, I think I might have used this before. I mean, it's very easy. Most questions aren't this easy, but you get to a DM and they say, well, we're going to have your hearing in writing. And you look at the statute and it says, all hearings shall be in person. And so right away you say, oh, well, DM, you're supposed to have oral hearings, in-person hearings, right? So you can't just give me a written hearing. That's in violation of your own statute, right? So that would be the easiest JR ever, because the answer is so simple. But I use the simple example because it's just a good one to remember, because it can of course get more complicated and not as straightforward as all that. But the point being that that's where you look. The first place you always look is the statute. What does it say about procedure, and does it help me with my problem, whatever my problem might be? So we'll talk about that. So that's why, is the home statute or regulation or general procedural statute give you the answer to your problem? So do you remember, what do we mean by home statute? What is that? Yeah, enabling statute is another name for that. What does that mean? Yeah, the one that created this DM, that brought it into this world, gave birth to the baby. Now we're getting very graphic, but it's the baby, right? The legislature creates these babies. It's all like getting medical and all that stuff. Anyway, they legally create this thing called a DM, and they do it by way of a home statute or enabling statute. And usually that's pretty straightforward. The Ontario Securities Act creates the Securities Commission. No surprise there. It can get weird with, a DM having like 3 different statutes, but don't worry about that. One of the statutes is going to create them, is going to bring them into existence. There shall be this thing, this DM called the Securities Commission. And this is what they do. A, B, C, D, E, F, G, they lay out what they do. And as we're talking about here, how they do it. But remember, they might not say much, right? Legislatures might say, okay, here, you're the Securities Commission, do this, do that, make these kinds of decisions. You figure it out, right? So the OSC says, okay, well, we can write our own rules and do our own thing. Do our own procedure the way we want to do it. It could be written, it could be oral, they could do electronic hearings, they can do whatever they want, right? Or it might say, the opposite is, here's how we want you to do it. We're going to spell it out, step by step by step, do it. This is the legislature talking now. This is how you should do it. We're going to describe it all. And that way they don't have much leeway, right? They have to follow those rules. In reality, usually it's somewhere in the middle. They say a few things about procedure, but not a whole lot. So you got something there. But it might be enough to give you an answer. Okay. When I say general procedural statute, what am I talking about? What is that? What's a general procedural statute? Yeah, in Ontario, and remember we only care about Ontario and Canada. There isn't one for Canada. Ontario has a thing called the SPPA. Anybody remember what that stands for?
I don't know.
Nobody knows. SPPA? No? I guess you don't really have to know. You should know. Statutory powers procedure. Yes. And this is a nifty little thing that exists that can be your friend. The SPPA can be your friend, so get to know it. You don't have to know it inside out, but have a look. Just look at the table of contents, because there's all kinds of cool stuff there, where the legislature basically says, all DMs in Ontario, basically, here's a bunch of procedural stuff, rules. And there's all kinds of great, interesting things in there that are really interesting for us, that are all about procedural fairness. They talk about written hearings, they talk about exchanging evidence, publishing decisions. There's all kinds of great stuff in there. So I'm not expecting you guys to be experts in the SPPA, but have some familiarity with it, because that's kind of something you want to do at the beginning of a problem, because you might get your answer there.
But if there is, if there are provisions in the home statute and the SPPA, the home statute would prevail.
It prevails. Okay, that's a really good question. We should talk about that. So I'm confusing you, right? You got the home statute, there's rules, procedural rules in there. At the SPPA, there's more procedural rules. Well, what if they fight each other, or they're in conflict? That can happen. It's rare. It's rare. usually think of it this way. It's a kind of a layer on top of the home. You have the home statute, you got a layer on top of the SPPA, and usually it's not saying the complete opposite of what the home statute says. But you're right, if there is a conflict, the home statute's going to prevail, right? And that fits with our notion of specific overrides to general, right? So if the SPPA says, sure, you can conduct written hearings, and the home statute says all hearings are in person, well, who's going to win? Yes, the home statute's is gonna prevail, but that's not likely to happen. But you've got to be aware of that potential conflict. Does the SPPA apply to every single DM in Ontario? No. Ontario. There's all this qualifying language. It doesn't apply to every DM. But again, I'm not so worried. Again, that you become experts in knowing the ins and outs of the SPPA. Generally, it applies to the kinds of DMs that we talk about, the DMs that hold hearings and make decisions that we're kind of familiar with, like the College of Physicians and Surgeons, or the OSC, or these kinds of decision makers that generally hold hearings. So it mostly applies to most DMs. Again, I don't expect you to know all the ins and outs of it, but know that there's a very good chance it's going to apply, and it might help you with your problem. Okay, so if you overlook that, you might be missing something really valuable, really useful in helping you with your problem. Yeah, so I have the examples here. The first bullet is the easy one, the statute or the regulation. Remember, statutes have regulations and they're kind of part of the statute. So if they, in the regs, might say something, for example, there must be an oral hearing, it was denied, you would just go to court to enforce that. But remember the second bullet there is the tough one, where it says no oral hearings. What can you do? And remember, we know that the common law will not help you, right? Because the common law is weaker than the statute. You can't bring in the common law to rewrite the statute. It's not going to work. You're out of luck unless you can go so far as to use the Charter or the Bill of Rights to override the statute. Ask a court to do that for you. And we've already seen, and we're going to see more cases where that actually happened. But bullet 3 is kind of where most of this interesting stuff happens that we're going to talk about, which is you go through the statute, you go through the regs, you go through the FPPA, and you still don't have an answer. So you got to go to the common law. All right? Baker. We're going to talk more about Baker quite a bit tonight. So that's where common law, B, is where all the interesting stuff happens, and where admin law professors like to ask you questions on an exam. They want you to know how to do a common law analysis of a procedural fairness problem. Right? Big picture. Any questions so far? It's been a while. You haven't been thinking about this stuff. Okay. So then we get to B. B's where all the fun happens. Common law. Right? Where we don't have that easy answer. And we've got this framework. And remember, I emphasized over and over again that the courts say, and the common law says, not every DM owes a duty of procedural fairness, which shocked you guys, and I think you're still in shock about that. But it's true. The reality is not every DM owes a duty of procedural fairness. So we have to answer that preliminary question. Quite often the answer is going to be yes, but we can't just jump over that. We've got to think about it. And that's where our Knight three-pronged test comes in, right? And the heart of that test is rights, privileges, or interests. Are rights, privileges, or interests affected? And these two bullets under Knight are really important because we know that there's a couple of really important areas where the answer is actually going to be no. The answer to that question, number one, is going to be no. Or probably is going to be no. So the first one, preliminary decisions, right? Like investigations. And why does that make sense? Don't we all want to have fair investigations? Again, it's easy because intuitively you think, well, shouldn't everything be fair all the way along? Like, how hard is that? Everything should just always be fair. But we learn in admin law, it's like, well, we're not so sure. Not everything. And we've got this investigations. Do you guys remember the example I used? Maybe I used it. It's been a long time. Investigation stage. In criminal law, what's the investigation stage? Who does that? In criminal law.
The police.
The police, right? Do the police have to be fair? No, they're biased, right? They're always biased. As soon as they think, you're the one who did it, they decide you're guilty, and they're going after you, and they're biased, and they're just going to try to get you in prison. That's their job. I'm exaggerating, but think of it that way. And if you run off to court and say, oh, the police are biased against me, they don't like me, and they're being unfair to me, the judge is going to say what? Sorry?
The procedural fairness is for the trial.
Yeah. Exactly. Another way we put it is you'll get your fairness later, right? Your fairness is coming, don't worry about it. You're going to get a judge later on at a later stage, right? Past the investigative stage, you're going to get procedural fairness. So don't come crying to me now. Yes, you're probably right. The police are probably biased, but so what? That's the way our system works. And you're not entitled to fairness. Not yet. And we use the term sort of preliminary. An investigation stage is preliminary. It doesn't have to be an investigation, though. It can be any kind of preliminary stage. And you see that in admin law, in the tribunal world, where they have these stages. It happens all the time. Well, we're at the, inquiry stage of the process. So what's that? Well, it's a stage that comes before the hearing stage or the decision-making stage or something else. So often DMs, they have stages, right? And the more you can say, well, it's a preliminary stage, the more that you're going to say, well, if it's preliminary, that means there's no PF. Right? Because the fairness is going to come later. And here's our other really important point about where there may be no PF in common law, which is where it's what we call a legislative or policy decision or a general decision. So, give me an example. What would be a decision like that? Anybody remember?
cell phone.
The eggs and the chicks.
Yeah. That's the one, for example, for telephone
Yeah.
towers.
Yeah, another good one. So CRTC setting cell phone rates, affects the whole community, affects a broad group of people in society. Well, that's very different from making a decision, just about me, one person. So it's a general decision, has a general impact, and the courts say, no, we don't expect procedural fairness there. It's too general. It's legislative. It's not specific. So specific versus general. Yeah. Okay. So if you get through that, what comes next? Right? We have a duty of procedural fairness, which means the DM owes that person the right to be heard and the right to an unbiased decision. Right? And the right to be heard. What is that in restaurant terms? You don't remember? Mandarin. The Mandarin, yes, the Mandarin menu. We're going to see that menu tonight, finally. We've been waiting a long time. So the right to be heard is that, again, I call it the Mandarin menu. It's like every possible yummy dish. That doesn't explain it very well. Every possible benefit, food benefit, every possible procedural benefit you could ever expect to get in a hearing. And there's quite a few, probably more than a dozen. I've never counted. There's a lot, and we're going to go through that list. And it's kind of a checklist for you guys to go through and say, okay, on the Mandarin menu, yeah, I got that. I don't think I got that. So you can see if you can get that. Or argue to a judge, hey, I didn't get that one benefit and I should have received it. I was denied this Mandarin dish. And the judge might say, yes, I agree with you. You were denied that. They should have given that to you. Or, of course, the opposite. Well, and the opposite is, well, we all want everything, right? Well, you can't have everything. You got enough procedural fairness. You got 5 or 6 of those benefits. You got 5 or 6 Mandarin dishes. You should be happy. Nobody gets all of them. So go away. And remember the phrase, oh damn, the phrase just left my head. Think of it this way. No court is going to say that a DM has to be perfectly fair, right? Procedural perfection is a phrase the courts sometimes use. So rarely, if ever, is a court going to say, oh, you should receive every single one of those benefits. That's rare. So think of it that way, that they're not always easy to obtain. So now we're here. What's the level of DM owed Baker? And that's what we're going to spend more time on today. We use Baker to get low, medium, or high, right? So that helps us. And it helps the judge. It helps everybody say, well, how much fairness really should the person have gotten in this situation? A low amount, a medium amount, or a high amount? And remember, it's not easy to argue that you should be in the high category, right? Those are not common. Medium or low are much more common. For high, there's usually got to be a lot at stake. And we're going to see what that might mean, what kind of cases. Okay. We haven't even got to slide 1 yet, so I should probably move on. But I think this is important refresher. And so this is kind of what I was talking about. We say, okay, is it low, medium, or high? And then we kind of finish by saying, okay, based on low or medium or high, what procedural benefits, Mandarin menu, did you expect to get but did not get? And then and the court is going to say, well, is that a reasonable expectation based on the level of fairness and based on what other courts have said in the past about that benefit? And we're going to see some case law that's going to give us some guidance. Right? And the classic one, oral hearing, which is kind of the highest procedural fairness benefit that we can ask for in a way. Courts have said that it's normally not going to be expected, except in certain specific kinds of situations. But for the most part, they're going to say, nah, written hearing is fine. Written hearing is fine. Not everyone can or should get an oral hearing. Okay. And then of course we have the Charter Bill of Rights, which we've kind of already touched on, which we know and we learned last class that we can use that, and we've got a framework for those, for Charter and Bill of Rights when it comes to fairness, right? Section 7 of the Charter, we can use that to strike down or deal with a statute that's a problem for us when it comes to fairness, because that's our only hope. We don't have that. We have nothing because the statute's going to win. The statute's going to win the day. Okay, everyone's mind is now sharpened up again. Maybe yes, maybe no. Okay, well, it's going to get sharper. Any questions? So that's the big framework. And now what we're doing is we're filling in the spaces here and there, so we get a better understanding of how to do these things. All right? We did that already, and now we're kind of here on Baker. Really, really important, and it's weird. That's what makes it bin law weird. You spend so much time analyzing: is it low fairness, medium fairness, or high fairness? It's like one of the biggest things in admin law. If you tell anybody else that that's like the most important part of admin law, they think you are nuts because it doesn't even answer your question. But it's important to answering your procedural fairness question. And the courts want to hear your Baker analysis every single time when it comes to PF. Okay. Let's get started on if I can find my slides. This is kind of reinforcing what we've just been talking about. The existence of a duty of fairness does not determine what requirements will be applicable in a given set of circumstances, right? Because Knight tells us, again, at common law, yes, there's a duty of fairness. Just answers that simple question. But it leaves you not knowing, well, how do I know if this person was treated unfairly or not in this situation? Well, here's how you know. You go along with the framework and you use Baker. So, and there's this quote here: the concept of procedural fairness is eminently variable and its content is to be decided in the specific context of each case. Okay, and there's a little example of potential procedural benefits. Mandarin notice, pre-hearing discovery, right to counsel, oral hearing or written submissions, reasons. This is a partial Mandarin menu right there. Okay. So before I start on Baker, let me just say that, and this is important, what you're really doing, what you guys are going to do when you see a DM, is you're analyzing the DM, the statute. So you say, well, who are these people and what do they do? So in other words, when you're doing your Baker analysis, you're not talking about, and this is a super common problem of students who during the Baker analysis want to talk about, oh, well, you know, so-and-so should have gotten an oral hearing, or it wasn't fair when they withheld that document or that report or something like that. Don't do that. Don't do that. It's very methodical, step by step. All you're doing here with Baker is saying, what kind of tribunal is, what kind of DM is this, what kind of tribunal, and how much fairness should they give to people? That's all. And then you go look at what happened. You know, the awful things that supposedly happened and the unfair things, and then you make your decision. Okay. I probably didn't explain that well, but it's going to come out again and again as I go through. Okay. So we'll go through a little bit. You're probably familiar with the Baker facts. We'll do a little recap here. So there was an order made by DM to deport Ms. Baker from Canada after she'd been in the country 11 years illegally. This was a discretionary decision by immigration officials whether to allow her to remain in Canada on what's called humanitarian and compassionate grounds, H&C, humanitarian and compassionate grounds. She had suffered from mental illness and had 4 children while in Canada. Her application was denied by somebody called Officer Caden on advice from a junior officer called Lawrence. Okay, so here's the question. And it fits with what we've been talking about. What additional procedural rights were sought by Ms. Baker? Does the duty of fairness apply? Why? And we know, we have no problem when we apply the Knight 3-prong test. It was pretty clear, and it wasn't argued in the case that a duty of fairness was owed to common law. But the big question remains, what's the content of the duty? In other words, how much fairness was owed by the DM. So yeah, both parties agree. They say, yeah, okay, we all agree that this DM owed Ms. Baker a duty of fairness in common law. And the court ends up saying, well, the factors show that more than a minimal amount of PF is owed. And they describe it like this: a meaningful opportunity to present evidence, but relaxed. And we're going to see how they got there. And as far as content owed, they say, well, there was an opportunity to be heard through written submissions, but not an oral hearing. That was owed, and it was given. Reasons were owed, reasons were given. But we know that the decision was quashed on different grounds: reasonable apprehension of bias, which is for another class. And the decision was sent back, and a new decision was made, and Ms. Baker was ultimately granted the humanitarian and compassionate exemption from returning to Jamaica to apply for citizenship. And it's just, well, a reminder that a finding by a court that the duty of fairness has not been met will normally result in the decision being quashed and returned to the DM for a new decision, right? Remember that concept that we talked about? Where if a procedural fairness error is made, the remedy is quashed and sent it back, and the court quashes, sends it back, and says to the DM, do it again and do it right this time. You weren't fair, do it again, and do it in a way that's fair. So that's the normal outcome, and that's what happened here. But of course, we all know that that doesn't mean there's going to be a different outcome. As the court says, that we're not talking about outcome, we're just saying do it again and do it fairly. The outcome is the outcome, whatever it is. It could be exactly the same or it could be different. We know in this case it was different. Okay, I'll skip the other stuff there. Okay. I'll skip that because that's pretty basic now. So I'll just go to that last point here, that the degree of procedural fairness is determined by assessing and applying the 5 factors in Baker. The 5 magic factors. Okay. Now, technically, they're not exhaustive, because the court says, well, there could be other factors. For our purposes, there's 5 factors. Okay? Try to keep it simple. 5 factors. That's all I want you to know. Okay. Here they are. Magic 5 factors. There should have been some music that came on when I came out. This is an important slide. But these factors are repeated later, one at a time. So, number 1, the nature of the decision and the process followed. Number 2, the nature of the statutory scheme, the terms of the statute, pursuant to which the body operates, body, DM, the importance of the decision to the individual or individuals affected, the legitimate expectations of the individual, and the procedural choices of the agency itself. Okay. Read that and you go, I have no idea what they're talking about. But you're going to understand it by the end of today, for sure. Okay. So what are you doing here? These 5 factors, what are you doing? That was an unfair question. You guys don't know. Okay, what are you doing? Do you know what we're doing?
You're analyzing the efficiency, like which ones of them before proceeding for us and last, and then do a balance.
Exactly. So what we're doing, thank you, what we're doing is, to keep it simple for you guys, is you're putting in arrows. And I want you to use arrows. Do you know where the arrow key is on the keyboard? Up and down arrow or sideways arrow? Even if you don't, you can write the word arrow up or arrow down or arrow sideways. Okay, this is really key, important, because after your analysis, you're going to have, next to 1, 2, 3, 4, 5, you're going to have an arrow, and it's going to point somewhere up or down or sideways. Sideways being, that factor has kind of a neutral impact, makes no difference, sideways. Or up or down. What's an up arrow going to say? What's an up arrow going to tell us?
That the higher level of procedural fairness is shown.
Exactly. It's going to point towards a higher level of procedural fairness. But it's only a factor, right? It's a factor. So you could have 2 up arrows, a sideways arrow, 2 down arrows, and all they do is tell you what that factor does. Does it push the level of fairness up or does it push it down? So think of it as kind of, a needle on a speedometer, up or down, or a thermometer, hotter, colder, something like that. But it's only a factor, and it's only after you get 1, 2, 3, 4, 5 arrows, then you go back, you look at the whole thing, and you say, well, I think that means medium, or I think that means high, or I think that means low. Okay? So you're only getting a direction from each of the 5, as in up, down, or sideways. Okay, don't worry if you don't know what I mean by that, because we're going to go through this over and over. So, Baker factors number 1. The nature of the decision being made and the process followed in making it. So this is the first factor that we're being asked to evaluate and come up with an arrow that has some direction. Okay, this quote is really important because it guides you and tells you what we're talking about here in factor number 1. So the more the process provided for the function of the tribunal, the nature of the decision-making body, and the determinations that must be made to reach a decision resemble judicial decision-making, and I highlight that in red, the more likely it is that procedural protections closer to the trial model will be required. So what on earth does that mean? What are they talking about?
Is that the person will be entitled to higher procedural fairness if,
Right.
if the process and the nature of the decision is similar to what happened with the court?
Very good. Yeah, no, that's exactly right. But how do we know?
We look at the procedure, like the description of the procedure, or whatever it is in the regulation.
Yeah, well, yeah, exactly. But look at it this way. Imagine, and for here, what I want you to do is I want you to pretend that you're at that hearing, where the DM's holding the hearing. Does it look like a court? What makes a DM look like a court?
An oral hearing?
Yeah, for sure. Let's think of it. Let's think of it in TV terms. Law and Order. You guys watch that show? Terrible show. Sorry for those who like it. You know, you have the police and the rest of it, and then eventually, at some point, at like 12 minutes in, or no, it's 18 minutes into the show, there's going to be a trial, right? These trials, you know, they take 4 or 5 minutes. Very realistic. But what do you see, or what if you guys walked into Osgood Hall downtown, or the courthouse downtown, and you walk into the courtroom? What do you see? What goes on there? And I'm trying to keep it very simple and practical. What do you see in a courtroom? You see a judge up on a platform. Yeah. What's the judge wearing? It's not a joke. Seriously. What's the judge wearing? Robes. Right. So already we're getting a mental image of what a court looks like. There's a judge sitting on a raised platform, wearing robes. What else do you see? Yeah, you see 2 or more parties. You usually don't just see like nobody or just one person. Usually 2 parties, as in one side, other side. Yeah, they have it separate. Like, oh well, plaintiff's over here, defendant's over here. 2 parties that are looking exactly. They're giving each other dirty looks like the whole time. They're snarling at each other. They're throwing things. Adversarial is exactly the word I'm looking for. So 2 adversarial parties. What else? Who else is in there that's kind of important? Yes, witnesses. Live, actual humans giving testimony, witnesses. Yeah.
Security guard?
Not like a witness, like, well, here's a report, here's a piece of paper. Well, you've got like real people up there giving testimony. What else? You're missing some like really important people.
There's
a jury.
There's a court clerk there.
Well, who said lawyer? Who said somebody else said lawyer? Lawyers. Lawyers. Not always, right? Not always, but usually in Law and Order for sure. There's lawyers because they're important people in the story. They're lawyers for parties. What else do you see? I kind of hinted at it. Well, a jury, but yeah. That's pretty rare in mid-law, but sure. What else do we see?
The clerk?
What kind of evidence? Well, so there's oral evidence from people, witnesses. What other kind of evidence? Written evidence, documentary evidence. Okay, so these things that I'm listing are all the things that you would see on Law and Order when you watch a Law and Order episode. So it's a bit funny, but what the court is saying is, if it looks like a duck and it walks like a duck and it quacks like a duck, It's a duck. So if it looks like a court on law and order with lawyers and witnesses and oral testimony, documentary evidence, it's going to look like the trial model. It's going to look like judicial decision making and like the trial model. In other words, the courts are going to say, well, if they look and act like us, we are going to expect them to give a lot of fairness. That's basically what they're saying. So you don't talk about what happened in your case. You're just saying, if you were to randomly next Tuesday walk into this hearing of the OSC or the College of Physicians and Surgeons or the Law Society or the Ontario Horse Racing Commission, we talked about them, what would you see? And does it look like a trial? Does it look like law and order? If it does, the arrow is going to go up. Up meaning more what? More fairness. More fairness. Arrow up. It's just an arrow. It's not a conclusion. You're not making a conclusion. You're just saying, well, boy, this DM looks and acts like a court, like on law and order. Therefore, I think the arrow goes up and points towards more procedural fairness. More procedural fairness. Not high. Don't say high or medium or low. That's your conclusion at the end. Here you're just saying, I think this factor points towards more fairness. There's one more thing that happens. What happens in a courtroom when, and for sure on Law and Order, when somebody gets up on the stand and starts telling a story? Yeah, I swear an oath, for sure. So that's another element. Something else happens. Always happens in Law and Order. So I'm the prosecutor and I say, okay, I'm done with my witness. And then the defense lawyer stands up and says, all right, my turn. Cross-examination. We always tear that witness down, right? Okay, I lied. I'm guilty. I'm the one who murdered that person. Anyway, whatever. But there's cross-examination, another element of a trial model. Okay? Now we know, and you guys have learned, in the admin law world, you're not going to see that very often. You might see something that's close to it, but quite often if you walked in, you'd go, wow, this is really boring. There's nothing even close to what I see on TV. I don't really see a judge. I just see some person, dressed like me, sitting there, and or maybe they're wearing jeans or something. There's no lawyers. They don't seem to have any witnesses giving, oral testimony. This doesn't look very much like a court. But your job is to analyze it and say, okay, this looks like a court, this looks like a court, and that's it. And so you could also say, oh, here's what's missing. Here's why it doesn't look like a court. There's no witnesses. There's no judge. There's no lawyers, let's say. Okay? So all these things are going to give you hints as to, does it look like a court? Their normal hearing. Don't talk about your case, but the normal hearing that this DM does. Okay, does that make sense? So it's a bit strange. I kind of say, well, if it looks like a court, we're going to treat it like a court. But that's what it boils down to. Factor number one is really easy because you can just kind of have a little checklist of the things that make something look like a court and check them off. What about a written hearing? What would you say about a written hearing?
It's against treating this procedure as a
a written hearing doesn't look very much like a court, right? But would you just walk away, or would you say, well, hang on, what could there be about a written hearing that actually does look like judicial decision making? Can you think of an example in a written hearing? What would
You have to provide documents.
documentary evidence? Yeah, documentary evidence.
There could be.
Adversarial parties.
Understand.
Remember? Yeah, adversarial parties. So even a written hearing can kind of a little bit look like a court.
There could be lawyers.
There could be lawyers, exactly. So even if it doesn't physically look like a courtroom that you can walk into, it could still, you know, have some court-like elements that will make the error go up at least a little bit, right? So it's up or down or sideways. You might decide, I don't know, there's a few things here that look like a court, but there's a bunch of things that are missing, so I'm going to go sideways. And that would be a reasonable thing to do. There's some judgment here. Oops, I did something wrong. There's some judgment here. But the idea being, the more it looks like a court, the more you're going to get an up arrow. The more that's missing, the more it's going to be a down arrow. Okay. I know we're spending a lot of time on this, but these factors are all really important, and you need to get comfortable with how they operate. Okay, number 2, not my favorite factor. It's probably my least favorite. The nature of the statutory scheme and the terms of the statute pursuant to which the body operates. So this one's a little difficult to understand, but this quote helps us. Greater procedural protections, for example, will be required. This is from the Baker decision. When no appeal procedure is provided within the statute, or when the decision is determinative of the issues and further requests cannot be submitted. All right, I'd like to simplify this one, and you guys should treat it this way. Simply say, well, if this person is at the end of the road, there's no appeal lying ahead of them. They're at the end of the road. There's nowhere else for them to go under the statute in the process, then this will be an up arrow. It's almost always going to be up, because usually the person who we're talking about who says they were treated unfairly, it's going to be the end of the road for them, right? Which will mean arrow up. Okay, we also have this little factor, which is really very specific to Baker and doesn't really help us much outside Baker. So decisions that are exceptions to the general principle of the scheme may require less procedural fairness. For example, Baker asked for an exception to the general rule. Okay, that's great. It helps us a little bit in Baker, but again, it's not going to help us very much in other cases, because that's rarely going to be the situation. It's that first paragraph I want you to use to help understand what Baker factor number 2 is. Okay. Number 3, the importance of the decision to the individual or individuals affected. This one is dead easy. Really straightforward and allows you to simply, not so much be a lawyer, but be a typical person, just looking at the situation and saying, well, what kind of impact is this decision going to have on this person's life? But not only this person's life, but those around them. So in Baker, who is, going to be impacted by a decision to deport Ms. Baker to Jamaica? Sorry? Herself and family, her children. Yeah, exactly. So in other words, this factor is saying, look at the whole picture. What kind of impact is it going to have, not only on the individual, but on, could be their spouse, or could be children, their family, or even others. What kind of impact is this going to have of a yes outcome or a no outcome? Yes, you have to leave. No, you can stay. What is the impact? You can talk in human terms or just based on your life experience. If somebody's going to lose their license to practice medicine, sure, they're not going to be leaving the country, but it could potentially have a huge impact on their life and maybe on their family. But bring, again, bring your own experience to it, and you might say, on the one hand, yes, the poor person's going to lose their license to practice medicine, but what if they're, 85 years old? Not to be, age discriminatory, but you might say, well, it's different. Somebody at that stage in their career, obviously towards the end of their career, the impact's not going to be as great as somebody who's, say, 40, right, who has many, many years ahead of them practicing medicine, for example. So we just look at the human factor. What kind of impact will this decision have on the person's life and the people around them? So really easy. So when you get a story thrown at you, just look at the story. You tell us, you tell me what you think the impact is going to be. How significant will it be on that person's life? And of course, remember, the admin law world is so vast. There's so many different kinds of cases that we see that the impacts can vary widely. What was the, I think of the opposite example. What was the example I used about me? Remember? Yeah, the boating license.
Yeah, that you use for recreational purposes.
Yeah. There's a hearing, they're gonna, they've taken away my boating license. Keep that in the back of your mind, because that's one where you guys are all gonna kind of laugh and say, yeah, no big deal. It's David's, what he likes to do as a hobby. It's not going to profoundly affect his life. For me, I really love boating. But anyway, you get the idea that there can be all kinds of different things at stake. And if they're not so serious, which way's the arrow going to go? Which way's the arrow going to go? And then me and the boating license. You guys are mean, but yeah, down, probably down. Because it's a pretty low impact on my life compared to somebody like Baker or somebody who's going to lose their license to practice their profession, that kind of thing. It's obviously way less serious, and you're looking at either sideways arrow or down arrow, probably in my situation. Okay, you just can't compare. So, okay. That one's easy, straightforward. It's not very technical or legal. Okay, 3 and 5 usually are the biggies, but let's not worry about that for now. How are you guys doing? Can you hang in there? Can we get to 5? Let's get to 5. I really need a break. Okay, legitimate expectations of the person challenging the decision. So we talked about legitimate expectations before, right? So this is the same idea, and you learned before that if there's a promise made either by a DM of a procedure, the courts are going to hold that DM to that promise. It can also be a practice, right? Remember the example I used of there's a lineup of people waiting for a hearing and everyone gets an oral hearing. And you're standing in line patiently, waiting your turn, and you get there and they say, no, go home, we're doing a written hearing. And you're going to say, well, you basically promised me an oral hearing because you gave everybody else an oral hearing. You've been doing this over and over. You can't suddenly just change your mind and not fulfill your promise by way of your actions. But usually what we're talking about is a promise out of the mouth of the DM, in writing or orally, that, oh, don't worry, you'll have an oral hearing, or don't worry, we'll let you use a lawyer, or don't worry, we'll, some kind of promise. So, we know that legitimate expectations are not very common. In most situations, you're not going to find one. So, if you do that and you look and you see, well, I don't see any legitimate expectations argument here, where's the arrow going to go? Sideways. Neutral impact, no impact. Sideways arrow. Choices of procedure made by the agency itself. Okay, really important one. The thing to remember about this one is it almost always goes down. The arrow, for our purposes, always goes down. Let's take a minute to read this quote here. Particularly when the statute leaves to the decision maker the ability to choose its own procedures, or when the agency has an expertise in determining what procedures are appropriate in circumstances. So, pretty much we're always going to say, and the courts are always going to say, we're going to give some respect to the tribunal's, the DM's choice of procedure. Always. Some degree of respect, which means less fairness. Arrow's going to go down pretty much every time, and it can go down sort of even stronger if you can argue that the statute leaves to the DM the ability to choose its own procedure. For example, when the statute's pretty quiet of a procedure, or where the agency has an expertise in choosing its own procedure. Let's say it's been operating for 100 years. You know, they have a long history of expertise in deciding how to do their hearings. So the court's going to say, yeah, we're going to respect that. And we're going to say the arrow goes down. If you end up with an arrow up on Baker factor number 5, you've done something wrong. The best you might be able to do is say sideways. You might be able to say sideways. It's never up. Never up. Just like 3 is never down. There's always going to be some impact, or at least sideways. You might say in my voting license case, sideways, but that's as bad as it's going to get. It's never going to go down. Okay. So I highlighted this quote here. Important weight must be given to the choice procedures made by the agency itself and its institutional constraints. So again, here, this is the court saying, we're going to show some respect to this DM and let them make their own procedural choices. We're not going to second guess it. Okay, so you are literally, when you answer a Baker question, when you do a Baker analysis, you're going to use headings, Baker factor number 1, Baker factor number 2, 3, 4, 5, and beside or below every factor, you're going to have an arrow, or the word arrow. Arrow up, arrow down, arrow sideways. You must have that, otherwise it's incomplete. Because what it does is it allows you, when you're at the end, to say, okay, I see I've given 3 up arrows, a down arrow, and a sideways arrow. So what's that telling you? And then you make your own decision about that. Does that mean low, medium, or high? And it's, you know, unfortunately it's not math. It's not like you add up, it would be great. And of course, like, because it's law, it's like, well, there are factors, and you know, you assign them weight, this and that. So that's your challenge, is to say, okay, having done all the factors, I think a medium amount of fairness is owed because of, and you have to say something, but really, what you said under each factor is going to speak a lot to where you end up. Medium or high. If you, in that case, 3 up, 1 sideways, 1 down, what do you think would be reasonable? Yeah, medium or, sorry, high? Medium or high? Probably not low. 3 out of 5 up arrows is telling you something. But you know, but also remember, high fairness is hard to achieve. It's got to be a pretty important case. You know, not my voting case for sure. Yeah, and if you see 1 up, 3 down, and 1 sideways, what are you gonna say? 1 up, 3 down, 1 sideways.
That's all.
Probably low. Probably low. And remember, the courts they're very careful with this, and if you say high, they're going to really want you to back that up. High based on what? And I see that often. Students are like, yeah, I think I got high. I'm in high fairness. I think I got high. High fairness. Well, the courts are going to look at that and say, oh, you know, everyone thinks they have the most important case. They're going to be skeptical, right? So medium is going to be much more common than just in the day-to-day reality. But we know when somebody's livelihood's at stake, you're probably going to end up at high. And we see a lot of those kinds of cases. But if it's, say, it's just money at stake or something less critical, then you're probably not going to be at high. Somebody being deported, I mean, think about how significant that is.
So if we don't say that we are familiar and we agree that medium level of procedural fairness show say it's medium or it's better to say it's high and leave the court decide?
Yeah, strategically you might try to argue high. And then maybe the court will say, oh, nice try, but we're going to put you at medium. And in an adversarial case, you're going to say, oh, it's high, because you're defending the person who lost their license or whatever, or you're representing them. And the other side's going to say, no, this is low. This is a case of low. Right? And then, the court's going to decide. But right now, we're sort of thinking like judges. Like, what's the realistic outcome here? Low, medium, or high? So I'm sort of getting you to think as a judge would, what's realistic? If you're the judge, what would you say? You're absolutely right, though. Strategically, as a party, you might say, let's go for high. But you can't overreach, right? If you represented me in my voting license and you said high, you run the risk of the judge saying, your judgment's way off. The law doesn't support you at all. You've gone too far. Medium's basically the best you could hope for. And you'd be lucky to get that. So again, we're thinking like judges. What do we really think? And you can see with these factors, basically what we're doing is, again, we're not looking at our case. So if I throw his story at you, which I'm going to do, when you're doing the Baker factors, don't retell the story and what happened procedurally and how it was fair or unfair. You step back from that story and just say, okay, well, who's the DM and what's their statute? And I'm going to go through 1, 2, 3, 4, 5, and I'm going to come to a low, medium, or high. Then I will start talking about, what happened in this case. It's a mistake to, in your 1, 2, 3, 4, 5 factors, to start talking about, and the poor person didn't, get the lawyer of their choice, or they didn't get access to a report. You don't talk about any of that. Right? As the judge, you're just taking a kind of a cold look at this DM and how they operate and what's happening here before jumping in and solving the PF problem. Okay. What really happened in Baker? Does anybody know what the outcome of the Baker analysis was in Baker? Was it low, medium, or high?
Medium.
Yeah, it was medium.
Was more than
Yeah, which we simplified the medium. So again, a lot of students say, medium, I can't believe it wasn't high. This person was going to be kicked out of the country. But which of course is really, really serious. It's going to affect her family. But the court ends up saying, that's all true, and we accept that, we acknowledge that, but she was here illegally, and she was looking for an exception to a rule. She admitted she was breaking the law. So the court says, in that situation, median. If she was before that, and there was a question, was she here illegally, yes or no? Well, that would probably be different. Then you're probably looking at high. But she, sort of already admitted to being guilty of being in Canada illegally, so they say, well, that's all water under the bridge. We're now at the sort of her last chance. She can't expect the same level of procedural fairness that she could have in deciding whether or not she was here illegally. Anyway, that's a nuance that you don't have to worry about too much, but it's just interesting, and it illustrates how a high level of procedural fairness is going to be hard to achieve in any situation. Okay. So for the midterm, you guys are going to have to do a Baker analysis. I'll tell you right now, full disclosure. So that's why I'm spending a lot of time on this and giving you as much help as I can in how to structure an answer and what to look for. Okay.
Because from the Baker case, I don't remember if the court to emphasize that that measures.
I think, so when they talk about, well, she was seeking an exception to the rule, they said, and this is just from the statute, they were saying, well, she's not over here in, determining whether or not she was present in Canada legally. She was at this last, the last hope clause of humanitarian and compassionate crimes. And they said, well, that's a discretionary decision, and that's subject to less fairness because of that.
Because that's an exception from Canada.
Yeah.
Not because she's
Well, they're kind of hand in hand.
Like, the person could be in the good country and still applying for visas. And it's still local with an exception from the general rule.
Right. So they said the fact of the exception to the general rule is critical, but also that, anyway, we can talk about that. And it's, we're getting into kind of immigration law and that statute, and not so much, but we can't really take much away from that piece into the general analysis.
It's just because I'm confused whether this being illegal in the country is a serious factor, or it's just, we're just looking at this.
It was more that she was seeking an exception, a humanitarian professional grounds exception. Yeah, it wasn't that, oh, they thought she was a bad person because she was here illegally. Yeah, I did. If I suggested that, that's not really what they were saying. It was more about the statute and how this is kind of a faint hope discretionary clause. That makes it less of a need for a high level of fairness. Okay, I think a good time for a break. So can we get back at 7:30, please? These 5 factors played out in Baker. So, on factor 1, the court says, well, whenever we ask, does it resemble a court? How this DM normally operates, does it resemble a court? They actually end up saying, well, it doesn't really resemble a court very much because it's not a judicial kind of decision that they're making, because it's a discretionary decision that involves the consideration of multiple factors, right? Which is not kind of the normal thing that we see a judge do in a courtroom. So that ended up putting the arrow down towards less fairness in factor 1. They get to factor 2. They say, within the statutory scheme, the decision was an exception to principles of immigration law, although they acknowledge, well, it really is the end of the road for Ms. Baker. It's the end of the road for her. So they say, well, we kind of have a mixed result here in factor 2. you could almost say it ends up being a sideways arrow. So she's not doing very well in these factors as you go through. They say they have no problem in factor 3 saying that the outcome of the decision is going to have very considerable impact, exceptional importance to the lives of those with an interest in its result, Ms. Baker and her close family members. So arrow up. There was an attempt made to find a legitimate expectation that failed. They say there's no legitimate expectation of a special procedure created by what's called the International Convention on the Rights of the Child. In factor 4, sideways arrow, no impact. And in factor 5, they say, well, the minister here has considerable flexibility under the statute to decide on the proper procedure, and officers do not, in practice, conduct oral interviews in all cases, so the arrow goes which way? Down. Less procedural fairness. So when they weigh all that up, they say more than minimal, duty of fairness of owed is more than minimal, but it's not the highest either, so they end up at medium. And the way they describe medium here is, well, what's required here is a full and fair consideration of the issues, and the claimant and others whose important interests are affected by the decision in a fundamental way must have a meaningful opportunity to present the various types of evidence relevant to their case and have it fully and fairly considered. That was their overall assessment. Which you will need to do once you get your 5 factors. You're going to have to say something about what your 5 arrows mean and where you land on low, medium, or high. Okay, and we talked about this. Baker said, I expected to get an oral hearing. I didn't get one. And the court says, well, an oral hearing is not always necessary. Meaningful participation can occur in other ways. Here, Ms. Baker had an opportunity to produce full and complete written documentation, and the court says, this is good enough. This is good enough. An oral hearing not required to satisfy the median level of procedural fairness. Okay. Another point about reasons, which is one of the procedural benefits. She sought reasons. But we know the modern position of courts is that reasons are generally going to be required. The new procedural fairness generally is going to require a written explanation for a decision. In this case, she did get reasons. They weren't very good reasons, but she got reasons. So reasons is a yes or no question. Are you entitled to reasons? Yes or no? If yes, did you get reasons? Yes or no? If the answer is yes, done. The analysis is over. We're not, in a PF question, we're not analyzing the quality of the reasons. Right? When do we analyze the quality of the reasons? Substantive, exactly. Substantive review is where we do an analysis of the quality of the reasons. We don't care about that in PF. Ms. Baker ends up winning the day on reasonable apprehension of bias. It's just a quick note here about reasonable apprehension of bias. The court had no problem finding that the comments by the officer about her and her case exhibited bias towards her, and they were particularly troubled by the reliance on stereotypes, racial stereotypes, and they had no problem finding a reasonable apprehension of bias. And that's really what the whole case ended up turning on in terms of procedural fairness. Okay, another important and significant case is Suresh that kind of demonstrates how and when we do our procedural fairness Baker analysis. So in Suresh, the minister issued a security certificate stating that Mr. Suresh is a danger to the security of Canada, and that's one step to deportation. So Charter Section 7 was triggered in that case. They say, well, Mr. Suresh was able to file submissions, but he did not have access to a report that formed the basis for the certificate. They used the Baker analysis to assess whether the principles of fundamental justice in Section 7 have been met. And we talked about this earlier, that the principles of fundamental justice in Section 7 of the Charter really equate to what we understand as common law duty of procedural fairness. So they do in Suresh a similar kind of Baker PF analysis. They end up saying that the degree of fairness owed was high, and they say a person like this who's facing deportation to torture must be informed of the case to be met and provided with an opportunity to respond and challenge, although not necessarily a full oral hearing. And reasons must be provided. And they say in that case that the reason we got to a high level of procedural fairness owed is pretty much entirely based on the risk of torture, which is so serious. So now we get to the fine print. How is the duty of procedural fairness met? And here's the long-awaited Mandarin menu. Important slide, which you can use as a checklist to go through and see whether you or your client maybe has been denied one of these procedural benefits on the menu. Okay? So very important slide, important checklist. And we're going to go through most of these in a little more detail. So notice is, has a lot of aspects to it. One key aspect of notice is this idea of pre-hearing notice. So the fundamental idea of the person needing to be told the case that's made against them and to be afforded a fair opportunity to answer it. And we say that it's a fundamental right, and without it, other rights cannot be effectively exercised. And we have this added piece that if an issue goes to somebody's character or reputation, or has serious liberty or livelihood consequences, the courts are going to impose very stringent notice and disclosure requirements. Okay, so if your scenario fits with that, then you have a really good argument for expecting a high degree of pre-hearing notice. And look at that, we talked about this earlier, the SPPA. The SPPA helps us here, as it says, in Section 8. And again, we only talk about this when it's an Ontario DA, right? Only Ontario DA. And Section 8 says this: where the good character, propriety of conduct, or competence of a party is an issue in the proceeding, the party is entitled to be furnished prior to the hearing with reasonable information of any allegations with respect thereto. So this is really helpful. And for you guys, if you see that somebody, wasn't told the full story, the allegations against them, the documents that are going to be used against them, the witnesses who are going to testify against them, all of that stuff before the hearing, then that could be a problem. Okay? Because in these kinds of cases, there's a very strict, there are stringent requirements of pre-hearing notice. So you can use Section 8. It kind of goes hand in hand with the common law, but Section 8 is nice because it says it in a very easy to understand specific way, what we understand from the common law. Okay, sometimes we have questions around, well, how effective was the notice? Like the method of notifying the individual. So we have these interesting cases, for example, Hardy from BC, where the community was not given adequate notice of a school closure decision. And perhaps some kind of notice, I guess in modern times on a website or an ad in a newspaper would have worked to inform the community of a potential decision that's going to affect the community. The Central Ontario Coalition case, a case where, maybe there was notice, but it wasn't specific enough. There were no maps sort of indicating where these hydro lines were going to be going up and what specific decisions were going to be made about these hydro lines. We have cases like Rymall where they say, well, how much, if you're going to mail out a notice to somebody, how far in advance do you got to send it in the mail? Can't send it the day before, they're not going to get it in time. So how many days notice might you give? So you look out for that. When was the notice given and how effectively was it communicated to the individual? Okay, so we're working our way through the manner of venue, right? Just so we remember where we are. So pre-hearing disclosure and discovery, which is kind of related to what we just talked about. Really important, again, that somebody be given documents that are going to be used against them potentially in a hearing. Okay, I'm going to go to the next slide. May and Ferndale, really important case because it kind of sets the standard for what the courts expect from DMs when it comes to disclosure. Happens to be a case involving an inmate being transferred to a higher security prison. And Mr. May, who was complaining about being treated unfairly, says, I was treated unfairly because I didn't get all the relevant information to my case. All the information about me that the DM had. And the court ends up saying, they don't buy the argument. They say, no. In a criminal case, and those of you taking criminal law will know that there's this case called Stinchcombe, which has really, really high standard of pre-hearing disclosure of evidence and documents. In admin law, in our world, the Supreme Court has told us that no, that's not the standard. It's not so high. And the key phrase is the one I highlighted there. Procedural fairness requires the DM to disclose all information relied upon. All information relied upon. So that's going to be your common law standard of pre-hearing disclosure. All information relied upon. There's a difference between that and all relevant information, which is much broader and which is more appropriate in a criminal law context. So they end up saying that Mr. May actually should have been provided with records that were relevant to his case, that were relied upon by the DM, right? But you can see how that's not as strict as it would be in, say, a criminal case. So disclosure and official notice, we have this kind of basic principle that a party is entitled to know what evidence has been given and respond to it. It's a funny, unusual situation here with Kane, Professor Kane, and who was a UBC professor. He was suspended for improper use of a computer facility. A hearing occurs, but there's a side meeting at dinner with the UBC president, but not Kane. So the court has a problem with this because they say, well, this doesn't look right. Poor Mr. Kane, or Professor Kane, was not privy to that conversation. So the question was, or the allegation was, that the DM was hearing evidence in the absence of a party whose conduct was being challenged. Okay, so the party whose whose rights are being affected must be present when evidence is being given, or must be somehow be made aware of it. Okay, confidentiality and privilege claims. These are important because this is another complaint that you can have. You can say that, well, I didn't get access to this evidence or that evidence, and the argument could be, well, you didn't get access to it because it's privileged or it's confidential. So we have these arguments about, well, I didn't see that report, or I didn't see that letter, or I didn't see that evidence. Well, was it truly confidential or privileged, or should they have been given access to it? So we have on this slide some indications of different kinds of privileges that can actually prevent the person from gaining access to evidence that might be relied on. And we have the Pritchard case, which talks about solicitor-client privilege. So we know from the Pritchard case that solicitor-client privilege can override any requirement of disclosure, and we know that a DM can have their own privilege. That's what was established in that case, that the DM, the Ontario Human Rights Commission, had its own privilege, and it did not have to disclose communications between the DM and the DM's own lawyer. Another example is this idea of adjudicative privilege or deliberative secrecy. So in other words, you can't say, well, I saw the adjudicator in the hearing making notes, and I wanted to see those notes. And denying me access to those notes is unfair. Well, we know that there is this notion called adjudicative privilege, and no, you're actually not entitled to see an adjudicator's notes. As much as you might want to see them, and as much as you might find them helpful, you're simply not entitled to them. Okay, I'll skip this slide. A little bit more about the sort of the balance between the need for confidentiality and the person's right to access information that's going to be relied on by the DM. So you've got these competing interests at stake. And here's another example that where information was held from a person because they felt that disclosing the information could lead to some kind of harm. Federal court ends up saying, we don't buy it. We don't think disclosure would actually cause that harm. And the ruling was that the person was improperly denied access to information that was relied on. Although, in the end, even though there's a breach of the charter, they said, well, the breach is saved. So we don't learn a whole lot from that case. skip that one. Okay, staff studies, another example of a person saying, well, hey, I did not get access to the information that I needed, the information that was relied upon. So here's a case where the agency says, well, yeah, we had a staff report and we relied on it, but it was confidential. So that's why we didn't give it. And the court ends up kind of coming up with a compromise, and they say, yeah, staff reports can be confidential and can be withheld, but they say that if a staff report, for example, like this one, contains a statement of facts, well, you're going to have to give that. You're going to have to give that to the person complaining. You got to give them the facts, but you don't necessarily have to give anything more than that, like analysis or advice or recommendations or anything like that. Okay, delay. Another procedural benefit that's put in a funny way. Really, the procedural benefit is the right to a speedy hearing, the right to a speedy outcome. And we know that if there's a very lengthy delay, that can harm somebody's fairness rights, because their ability to respond to the allegations against them can be undermined by a long delay. We did talk about Blenco in the last class. But know that we've got this Cadelis case, which gives you a bit of a framework for analyzing when a delay is so bad that it actually is a breach of somebody's procedural fairness rights. So there's kind of this three-part test where we say, first of all, is the delay prima facie unreasonable? So when you're talking months, it's likely not going to be prima facie unreasonable. But if you're into over a year and that kind of thing, longer than that, then you may have a good argument about an unreasonable delay. But you don't stop there, because you look at the reason for the delay. Whose fault is it that this case is taking so long to be heard? And sometimes the person comes before the court and complains about delay, but it turns out the delay is largely their fault because of their conduct. They ended up, delaying the hearing, and we see that sometimes, where there's kind of an effort to slow things down and obstruct and delay the hearing. Delay the process. But sometimes, of course, it is the DM's fault that there's a delay, so they may have to be held accountable for that. And they also look at, well, what's the real prejudice to the person? What is the harm in this delay that's occurred? So these are factors that you look at in deciding whether a delay is going to be found to be unreasonable and breaching the person's procedural fairness rights or not. So here in Cadelis, they ended up saying, look how long these delays were in a number of months, 38, 47 months. They say, no problem, prima facie unreasonable. Who's responsible for the delay? The DM in this case. So it's not the complainant's fault, it's the DM's fault. And prejudice, yes. The court says, look, because of these really lengthy delays, there was prejudice in the sense of difficulty in obtaining evidence or memories fading or these kinds of things, where it actually does impair the person's ability to defend themselves. So they had no problem finding the delay was unreasonable. Okay, oral hearing, and we've talked about this, about, again, this notion that an oral hearing is not going to be necessary in all cases. In fact, in most cases, the courts are saying that, and have said that people are simply not entitled to an oral hearing, even though they may feel that that's the best way to get their fairness. Baker, an oral hearing was not necessary. In Singh, they end up saying an oral hearing is necessary to claim refugee status, so a different circumstance. Suresh, they say an oral hearing was not necessary, so these cases can go one way or another depending on the situation. But here there's this Hundle case, which is a really helpful one for us, because it gives us a little method to persuade the court that, yeah, you really should have gotten an oral hearing. And it's this keyword credibility. Okay? So here, let's say in your situation, you say, well, I've done my Baker analysis, I've got a medium amount of fairness, or maybe even low. So you're going to think, I'm never going to succeed in my argument that I should have received an oral hearing. Well, here's one way that you might actually succeed. You argue that this case turns on credibility. Who's telling the truth? A he said, she said kind of situation. So how does that make sense? Why would credibility be important? If you're the judge and I give you, you say, oh, I'm going to have a written hearing, and you get written submissions from one side, and they say one thing, and the other side puts in writing the complete opposite. Okay, decide. Yeah. Priscilla's saying, I don't think I can decide because I want to see these people. I want to look them in the eye. Because that's the best way to determine whether somebody's being straight with you and they're telling the truth. What's another method in an oral hearing that you don't have in a written hearing? Cross-examination, yes. Like in Law and Order, right? I get up on the stand. Oh, the light was green. The other side says the light was red. You get up and you start cross-examining me. Say, when did you last get your eyes checked or something? How do you know it was green? Or, I'm really nervous and sweaty, and you assess my demeanor, and the other side has a very different demeanor, and that's going to help you decide, who's telling the truth and who's not. So this is a really handy little tool for us to say, yes, I should have received an oral hearing. I know that's not applicable in all cases, but in my case, credibility was at stake, therefore I should have gotten an oral hearing, and that can actually succeed for you. But there's the Masters case, which kind of shoots that idea down. These were sexual harassment allegations. You might think, oh, well, credibility is really important. It so happened in that case, they said, nope, we're not buying it. There was no need for an oral hearing. So it's something you can try to use if you're seeking your oral hearing when you know you've got an uphill battle in almost every case. There's also this idea, and it's funny to talk about it as a procedural benefit, but we talk about an open hearing or a public hearing as a procedural benefit in a way. And whether a hearing was open to the public or not open to the public, in the old days, didn't really seem to matter. But in the modern era, the courts have said, well, we would like DMs to be open and transparent and have public hearings. And we're less comfortable with closed hearings. Why would that be the case? Who cares if the hearing's open to the public or it's not open to the public? Who cares?
Isn't there a decision taken for the individuals that never go through it intentionally for have better, take better before they
Yeah, you're definitely onto something.
Perhaps there will less
Yeah.
complaints, like, it's, like, nowadays I think it's just not possible in practice to have all. There are just too many complaints.
Right. But what is the benefit? So, if you're complaining, oh, my hearing was closed to the public, again, why does it matter? Why does it matter? You were starting to hit on it. Why does it matter? So let's say we're talking about an oral hearing, and either they lock the door, say nobody gets in. It's just the parties and their lawyers. I'm not letting anyone in from the public. Versus a DM who says, I welcome members of the public to come and watch this hearing.
Like the public policy decision or transparency?
Yeah, transparency. What does transparency do to a DM?
It makes them visible, like everybody's watching and.
Everybody's watching, yeah.
Yeah.
Yeah. It in a way, it keeps them honest. Keeps them honest. A reporter from the Toronto Star wants to come in and watch, which they may do from time to time. Maybe it's a high-profile matter. They should be allowed to come in. And there's a difference, a psychological difference between, lock the door, keep that reporter out, versus, oh, I welcome you, reporter. You're welcome to come and watch my hearing. You can see how it's a different mindset. If it were you, you're the decision maker. There's a reporter sitting there from the Star. First of all, it's going to make you nervous. But second, it's going to keep you honest, right? And you're going to be careful about maybe your conduct with the parties, and it's going to keep you honest, I guess is the phrase that keeps coming to my mind. Keeps you honest, because there's members of the public there, members of the media. You're going to be pretty careful about being fair and respectful and reasonable and all of these things. Because the last thing you want is a negative story, the Toronto Star, about what a horrible DM you are, or something like that, right? So you can see as a party, you want that. You want that. You want your DM to be reasonable and fair and open and transparent. So in a way, in a funny way, it is a procedural benefit as well. And the law is definitely tending towards requiring open hearings, open to the public hearings. And in fact, the SPPA, our old friend, the SPPA, says that there's a presumption that hearings must be open. So hearings must be open, and you better have a good reason why you're closing a hearing, is what the SPPA says, basically. But the SPPA says, okay, we're going to accept that there can be cases where a closed hearing is acceptable. For example, and we see here intimate financial or personal information is being discussed. A witness is testifying to a horrible assault or something of that nature, and you're saying, I don't want you as a DM, I don't want this hearing open to the public because I don't want that poor witness to have to, disclose their sensitive personal information to the world. You see it in the newspaper the next day. So I'm shutting this, I'm locking the door. Nobody gets in. That's reasonable. Or national security. See, national security is being discussed, and you don't want these kinds of, say, government security secrets getting out to the public. And really, like we were saying before, it comes down to the statute. So the statute itself can say all hearings are closed. It can say that. And in fact, the Immigration Act has a provision where there can be the opposite presumption. So you read the statute, which is going to tell you whether hearings are open or closed. It might address that very issue. Okay, here's a good one. Right to counsel, another procedural benefit on the Mandarin menu. We know that in Canada, there is no blanket right to counsel. At common law, there's no absolute right to have counsel in your hearing. And then we have the BC and Christie case where they tried on constitutional grounds to get the court to agree that there was a constitutional right to counsel. The court wasn't accepting it. Now the SPPA actually does speak to this question, and they say a party to a proceeding may be represented by a representative. So there you go. The SPPA has spoken on that issue and says, yeah, you can be represented by a representative. And that could be a lawyer, or they don't use the word lawyer, it could be a non-lawyer. But when it comes to the common law, the courts are, again, they're going to weigh up the situation, and they're going to hear you if you say, oh, they wouldn't let me have a lawyer. Well, that's not automatically a denial of procedural fairness. In some cases, they're going to say, you didn't need a lawyer. It's a simple case. My boating license. Well, I've got my lawyer. I've got this top lawyer. And the DM might say, yeah, no lawyers. Get away with your lawyer. That's the last thing we need. Tell that person to get it. So how do you know how to handle that situation? Well, like a lot of things in admin law, they say, well, let's look at the situation. First of all, how much PF are we talking about, low, medium, or high? Of course, that's going to be your primary question. But also they're going to look and see, well, what interests are at stake? How important? What's the impact on the rights? What are the upsides and downsides of including a lawyer? Is there possibly a downside? So lawyers can, with all due respect to lawyers, they can increase the cost of the proceeding. They can, end up delaying the proceeding. I get my lawyer to bring all kinds of motions and adjournments and drag my hearing out for a year, 2 years, because they're doing all these fancy lawyer things. And perhaps the most important question here would be that final one. Are there complex legal issues arising in the case? The more you can say that, the more you're going to say, the court's going to say, yeah, you should let the person have a lawyer. You can't expect people to, you can't expect a non-lawyer to be able to understand the complex legal issues or the complex court-like procedures. Right? A super informal hearing is one thing, but a very court-like hearing is another, where most ordinary people are going to be super intimidated, and they're really going to want a lawyer to help them out. Right? So you weigh up those factors in deciding whether a lawyer should be allowed or not. So Parrish is a case where this issue did actually come up. You don't often get these cases. A captain of a ship who was involved in a collision was being subject of a hearing where they were going to look at whether he was negligent in this accident. And in Parrish, the decision maker says, basically, I don't want you having a lawyer. Probably for the similar reasons we discussed. You don't need a lawyer, we don't want a lawyer involved, so no, we're not letting you bring a lawyer to this interview. The court wasn't happy with that. They said on their procedural fairness analysis, the DM should have allowed the poor captain to bring a lawyer with him. And they said, especially in this case, we have an individual who could be deprived of their rights or their livelihood because their ability to operate a ship was going to be in question, really their livelihood. was at stake. But they added this little point here, which is interesting for us. They say, well, a tribunal can limit the number of counsel, but not refuse representation. So, you watch The Simpsons? You're Mr. Burns, big Simpsons fan. He says, I have my lawyers with me, and he opens the door, and like 7 lawyers walk in. They all have briefcases, I want 7 lawyers. Well, if a DM says you need to pick one, you don't need 7, then the court's going to be fine with that. So they can limit the number of counsel, but they can't say you're not entitled to any counsel at all in a serious case like that. In a less serious case, the courts might be okay with banning lawyers. Okay. Is there anything interesting from this slide? I don't think so. I'm going to skip it. And then, Howard, is it just a case where the idea of a charter right to counsel was discussed? And we know that there is no charter sort of blanket right to counsel, but we do know that when we're doing a charter Section 7 analysis, right? Life, liberty, and security of the person in accordance with fundamental justice. Well, fundamental justice is common law procedural fairness, and we've already learned back here that common law procedural fairness could require a DM to allow somebody to be represented by counsel. Okay, so this is kind of a variation on this theme, or a sub-issue. An unusual, very unusual situation where the court not only says, yeah, you should let somebody have counsel, but even more than that, that the DM, in this case, should have allowed, or that the state should have provided counsel to the person and paid for that lawyer. So a very rare, very unusual situation. And under Section 7 analysis, the court ends up saying, because of the seriousness of the issue, the complexity of the proceedings, and the particular capacity of this parent whose child, was going to be, or had been taken away, and that was the issue of custody, they said the charter not only requires counsel, but requires state-funded counsel. So that's an extreme case where you can go even further than saying, yeah, counsel is required. The state must pay for that person to have a lawyer. But again, very extreme circumstances. Okay. Another procedural benefit we talk about is admissibility of evidence. So, let's just take a simple situation where you say, I want to bring in my neighbor to testify in this case. And the DM controls their own procedure, right? And they can say, I'm not interested in hearing from your neighbor. I don't think they can add anything. Or, I have a document I want to put into evidence, and the DM, pushes it back and says, no, I'm not allowing you to submit that as evidence. So DMs can control their procedure, and they can make evidentiary decisions, right? They can accept or reject the admissibility of evidence. So our starting point is tribunals, well, two things. A DM has discretion to decide how it's going to manage the evidence, and it can make decisions about what gets in and what doesn't get in, right? And we also know that first point there, that tribunals are not governed by the rules of evidence that courts use. Okay, that's our starting point. So this is where our DMs are, in a way, even more powerful in courts because they have way more flexibility. Right? We all know, like in courts, in criminal or even civil matters, there's rules of evidence. There's big textbooks with all the rules of evidence, what's admissible, what's not admissible. Well, Our DMs, they can basically throw the rule book out. They're not bound by any of that. However, the courts say, sure, they can throw the rule book out, but the rules of evidence, we're still going to consider them relevant, and we're going to think about them if there's an argument about admissibility of evidence. Okay, so we have the Miller case where tribunals, it so happened a tribunal preferred a document as persuasive evidence over 4 witnesses who testified to the opposite of that document. The person complains, how can they prefer a document over 4 witnesses giving evidence? And the court quite rightly did what we would expect them to do, which is they say, we don't care. That's for the DM to decide what evidence to prefer, not prefer, admit, not admit. We're not going to intervene. So they stay out of it. But Tim Power is the opposite. Tim Power in Air Canada had to do with harmful effects of secondhand smoke. They say, the court ends up saying, well, you shouldn't have barred the evidence. You should have admitted it, even if you thought it wasn't very persuasive. So what are we to make of all of this? Again, you go with your starting point. The tribunals are not bound by the rules of evidence, but at some point you might be able to argue to a court that a DM has done something unreasonable or improper by refusing to admit evidence or admitting evidence it shouldn't have or something like that. So you can always make these arguments. And to the extent that a DM just says, I'm not hearing it, I don't want your witnesses, I don't want your documents, if they're going to shut out evidence, the more they do that, the more the courts are going to be concerned. They're not going to care at all about how a DM weighs evidence. That's not their concern. But they might not be impressed if a DM simply, shuts somebody down and refuses to allow them to put in evidence. Okay, so you might have an argument there. But it's going to be difficult because the courts do not want to intervene and they want to let DMs do their own thing when it comes to evidence. And they're not going to, throw the rule book at them and say, oh, why do they allow hearsay evidence? We don't care. DMs are not bound by, the rules of hearsay and so forth. Okay? Now you're even more confused than you were when I started. Okay. Cross-examination. Another procedural benefit, right? Back to the Law and Order TV series, right? We all think that we would love to have the opportunity to cross-examine because we're going to destroy that witness and we're going to win the case. So yeah, it's a procedural benefit. So the SPPA weighs in on this and they say, well, yeah, cross-examination should be permitted where it's reasonably required for a full and fair disclosure of all matters relevant to the issues in the proceeding. Okay, so now you've got it. If you have a situation where the DM and the DMs can do this, they're going to say, yeah, I'm not going to allow cross-examination of this witness. You say, I'm entitled to cross-examination. The court's going to say, no, you're not. Remember, not bound by rules of evidence. But if you pull out the SPPA and common law that supports that, you might actually convince a court to say, DM, you acted unreasonably by denying the right to cross-examination, by denying the benefit of cross-examination. Okay, so again, your starting point is, who cares, they can do what they want. Cross-examination, no cross-examination. The DM, they run their show, let them be, but you might have an argument. If your cross-examination ability is denied, you might have an argument that the DM crossed the line and was unfair by denying that right. So SPP is a really nice kind of, it basically reflects the common law. We're reasonably required for full and fair disclosure of all matters relevant to the issues we're pursuing. Maybe yes, maybe no. It's your judgment call when you're challenged. Wow. I went fast through that. So, any questions? So do you understand, again, like how this all fits in our framework? So what we're doing is we're looking at all these procedural benefits. And we're using low, medium, and high to inform all of this, right? So if you're at medium or high, you're going to have a stronger argument that all these benefits should be given to you. If you're in low, weaker case. You're not going to get, you're going to have a harder time saying, you know, I'm entitled to all these benefits that we're talking about.
So if you're at low and medium, how do you know which ones are excluded and which ones are included?
You don't. Okay, yeah, there's no easy way of saying. I can never tell you, well, at low, you never get cross-examined. It doesn't work that way. But it informs how carefully the court's going to look at something. Let's just take that as one issue. If you're at low, the court's probably going to look at that and roll their eyes and say, really, was it really that important? If you're at medium, they might say, let's look at the SPPA. And if you're at high, they might say, oh, you denied cross-examination of that key witness? Totally unacceptable, work washing. That was totally unfair. See what I mean? It's almost like your mindset is affected by low, medium, or high. And that's the way courts work. They do the Baker analysis, they get low, medium, or high, and then when it comes to all these things, they've got a certain mindset, either strict or not so strict. And I know that's not, if only it were easier, but it just isn't, it isn't the way they work. But when you're tackling a problem, you're gonna say, okay, I'm coming into this problem, let's say, with low fairness. So I know I better have a really strong case for admissibility of evidence, disclosure, cross-examination, notice, all of these things, right to counsel. I've got, in other words, I've got more work to do. I've got an uphill battle to argue that I was denied. It doesn't mean you can't win. You've got a tougher road to take when you're at low. At medium, a little bit easier. At high, even easier than that. So I'm glad you raised it, because it's not as if you say, well, here's the menu for low, it's a bigger menu for medium, and it's a bigger menu for high. It isn't that way. All of these things, everything on the Mandarin menu is in play, whether it's low, medium, or high. It's just a question of how tough the court is going to be on the DM and how high their fairness expectations are going to be.
How does the reasonable apprehension of bias issue fit in with level of procedural fairness and procedural benefits?
That's a good question. It's actually a very debated question. For your purpose, you can argue that, oh, well, if it's high fairness, there's a stricter test for reasonable apprehension of bias. I don't think I expect you to go there. I would just treat reasonable apprehension of bias on its own, and we're going to learn what the scope of that is. Yeah, you can use low, medium, or high to inform that. Some courts say, no, that's wrong. You don't do that. So I think for our purposes, to keep it simple, let's not worry about it. Let's consider that to be on the side and not really affected by low, medium, or high. But you can see the argument. Again, my boating license. There's not much at stake. So you can see a court saying, well, if there was a lot at stake, I'd be really uncomfortable with this amount of bias. But really, does it matter in the end so much? Not so much. So, but I prefer to keep it simpler for you guys and to say it doesn't really matter. It's a thing on its own, reasonable apprehension of bias, which we're going to get into later. No other questions?
We're gonna try to do some practice problems in class.
Yeah, we are for sure. It's a question of timing. You know, the NCA exam, the NCA mid-law exam, have you guys seen that? The standard exam. You'll find it really easily on the NCA website. So I like to use that as an example. If we have time, maybe next week I can take up one of those questions and kind of show you how you work through the analysis. And usually, you know, Baker is central to that, but also how do you take Baker and then apply, you know, the Mandarin menu stuff to a low, medium, or high. But that's, have a look at the NCA exam. Maybe we'll take some time to take that up. If I get something to write on, we can kind of, as a group, you know, take a bit of time, read the question, come back, and kind of, as a group, collectively work out what we think a decent answer would be in that kind of situation. And remember, there's no perfect answer, right? So you can do really well. Two people can do really well and get the same high mark who don't even really agree with each other. That's not so much what matters because you bring your own opinion to it. What matters much more is that you kind of follow the framework and you kind of stick to the way that we analyze a problem. If you come up with a different outcome, that's fine. I don't care so much about that. It's sort of, it's in how you get there that's more important than the end result. Yeah, and that's you know, real life is, you know, practicing admin law is being able to give apply the framework to a situation and kind of do the best you can with what you have. Okay, but the NCA, I think there's at least 2 questions that touch on procedural fairness and 1 or 2 on substantive review. So we're going to, at some point, look at both. Okay, and I think also next week we release the take-home assignment, and it's due, I believe, 2 weeks after that. So we can spend some time talking about the assignment as well. I'll have to talk about the timing of the release of the exam, whether it comes out that night or that afternoon. I'll talk to the staff about that. So, but you've almost got all the tools you need to write that exam, but we're gonna be taking PF further next week. But the exam, as I was saying, it's going to be basically testing your ability to apply the Baker analysis to a fact situation.
So it's one problem question.
Yeah.
No research.
No. 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 Okay, it's early, but I know it was tough. You had a long layoff, and you had to recall everything and bring it all back. But now I think we've got like no break.